My lord, it's regarding item number 5, my lord.
5.
My lord, the matter will be adjourned for 2 weeks, my lord. I have got some personal difficulty and I have also taken consent from other side, my lord. It's regarding regularization of law college lecturer of Guwahati University. Regarding applicability of Uma Devi, my lord.
But you are appearing on behalf of
On behalf of the REIT appellant, my lord, Guwahati University.
appellant. But the notice is 4, 2, 4, and 5. Who is appearing for 2, 4, and 5?
My lord,
My lord, I am appealing for one, my lord.
One.
Office note, my lord, the service is not complete, my lord. I have seen my office note.
Services are not
Bar
complete.
Council of Assam.
In respect of respondent number 2, 4, and 5, the service is not being complete.
My lord, we have already taken steps, my lord, but the AD card has not.
Let the number come.
Ask.
My lord, I beg to mention item number 2, my lord.
Yeah.
Item number 2, my lord, some development after the result of SLP, my lord. Some development has taken place, my lord, about the release of my arrears, my lord. So
What development?
development, my lord, they are in processing, my lord.
They are providing you appointment.
No, my lord, regarding, my lord, my salaries and
Salary.
arrears, salary and pensionary benefit, my lord. The state has gone to the Supreme Court, my lord.
That SLB has been dismissed.
Dismissed. So, my lord, I pray, my lord, some 3-4 weeks time be granted to me.
You are for
I
appellant.
am for the appellate.
4 weeks time, Lord.
Dane om.
When a concept of the appellant is submitted after dismissal of the SLP file by the state government is processing to make payment of arrears to the appellant. It prays that the matter may be adjourned just after 4 weeks.
May I please, your lordship? I beg to mention item number 21 of the list.
Yeah.
With the consent of the other side, matter may be adjourned for 2 weeks, your lordship.
Adjourn.
Of the state.
May I please, your lordship? I beg to mention item number 17, lordship. For
Yes,
adjournment for a day.
delay condonation 19 days.
Item number 17 and 35, lordship, same.
No steps for issuance of notice in respect of the respondent till date. Remember, wait your turn. Wait for your turn.
May I please, lordship, I beg to mention for listing, my lord.
Listing.
My lord, any date after 1 week, my lord.
It's a fresh matter.
No, my lord. Hearing matter, last occasion, my lord, matter was left over.
And what date was fixed on the last occasion?
Last, my lord, 3/4/2024.
3/4/22. Then on that date, it was not listed.
Listed, my lord, but it
Then
was left
what-
over, my lord.
What order was passed?
It was left over, my lord.
Leftover? There is no leftover in this. There is no chance of leftover. Show us the order. P4 order. Give it. Get a printout.
May I please, your lordship? I beg to mention item number 23 and 24. Kindly adjourn the matter for 2 weeks, lordship. I have taken consent, lordship.
Adjourn. 4 weeks. Adjourn.
Lordship, in item number 36, we have filed an affidavit in opposition that may kindly be called for.
Also the affidavit.
Lordship,
That affidavit is already on record. By the state of Assam.
Lordship,
That is Kamakhya temple matter.
uh,
Yes.
yes, Lordship.
That is already on record.
It was filed on Saturday, Lordship.
मेरे पास में नहीं
Lordship,
मंगवा लें अगर नहीं है तो
May I please, your lordship? I beg to mention.
Yes,
May I please, your lordship, I beg to mention item number 35, adjournment for the day, lordship. 35. The engaged counsel is out of station, lordship.
Been admitted.
adjourn.
Please, my lords.
Yes,
As I beg to mention a fresh writ appeal for admission listing, my lords. Before Bihu vacations also, my lords, I had mentioned this matter. This pertains to the conduct of buffalo fights during Bihu, my lords. For admission listing on Thursday.
next week,
Next week, my lords, it's 1st May.
first May.
1st May. Great.
May I please, my lordship? I beg to mention item number 28. Kindly adjourn the matter for a week.
Adjourn.
Much obliged. May I please, your lordship? Lordship, I beg to mention one matter, that is WBC number 6773 2023. Harshit Pathak versus the Union of India and 4 others. Lordship, that matter was last listed on 24 November 2023. But thereafter, on that day, interim order was passed. Interim order was granted, but that interim order was not made in online till date, Lordship. Thereafter, the matter was not in listed. So I pray,
Was
Lordship.
it by this court? No.
No. On the court, the last order was listed before learned justice, Mr. Amar Pathak, on 24 November 2011. And I had also made representation, lordship, before the registry, but the matter was not listed.
You have to
Call for the list the matter before this court.
Obliged, madam.
Daily list for orders, item 1.
Is your lordship. Lordship, in this matter, we have received the current address of the respondent. So may I be allowed 3 days time to take steps upon.
already on 15/3/2024, time was granted.
Lordship, the respondent was not available in that address. This is the new address which we have received from the department, Lordship. We have just received last week, Lordship.
In concept of the petitioner seeks 3 days more time to furnish fresh/correct address of the full respondent.
We have received the address. I'll take steps within 3 days, Lordship.
Please submit, then only will.
You have to first file amended cost title. You can't just take step like this.
Yes, Lordship.
It's up to the- Yes,
Item number 3.
Here, my lord,
Wait, this is not.
both the contempt, in the meantime, they have retired from service, my lord, and the contempt number 2, in the meantime, expired, my lord.
this Pritam Kumar Sekia.
He retired from service. Then Sanjeev Kumar Bhuya,
Bhuyan,
he expired, my lord. Both of them have retired. After retirement, Sanjeev Kumar Bhuya expired, my lord.
yes,
My lord,
you have to take fresh steps.
yes, my lord, I have to file an appropriate application to implement the newly
The
party.
concept of the state has informed that. Respondent number 1 is now retired, whereas respondent number 2 is expired. And the concept of the petitioner seeks some time to take steps for substituting the new increments in place of respondent number 1 and 2. Time period for the granted list of 2 weeks.
Obliged.
Item 4.
May I please, Lordship? In this case, my lord, the earlier occasion, we have submitted that finance department approval has not been received.
Yes.
My lord, today, my learned can inform me that finance department already
On
approved.
15/3/24, my lord, the finance has approved the proposal, my lord, for appointment of the redevelopment under compassionate ground matter. We have already approved.
And now who is going to appoint?
My lord, I have to take instruction. 2 weeks time may kindly be granted.
Why 2 weeks?
My lord,
Occasion or-
finance department already approved. Today, my lord, today, my lord, my learned.
2024, and
Or-
now it's almost 1 month has passed. Why you are not taking?
Or she may already, he may be appointed in the meantime also, my lord, my learned. So I have to take that instruction, my lord, whether she is appointed or not. That must, my lord. We are waiting for the approval of the finance department. Since my lord,
There,
no, my lord, that has been approved. Today, my lord, I came to know about the approval,
2024.
my lord. That's true, my lord, but we do not have any communication with my department. Only to take instruction about the appointment.
On 14/3/2024. This court directed Mr. R. Borpujari, Leonard Sterling, Council Finance Department, to complete his instructions as why the matter regarding compassionate appointment to the appellant referred by the state level committee has not been approved by the finance department. Mr. Borpujari has today informed that the finance department has already granted its approval on 15/3/2024. Stop. Learned counsel appearing for the Mines and Minerals Department, Government of Assam, has submitted that he came to know about the approval granted by the finance department today only. He placed some time to complete his instructions. Stop. Since the approval of the finance department has already been granted, there is no point in granting more time to the Mines and Mineral Development Department. However, in the interest of justice, a week's time is granted to the Mines and Mineral Department to accord appointment to the appellant list on 30th of April. On that day, bring the appointment also.
Today I am appearing, my lord, we go good.
Item 5.
We have already taken steps, my lord. Respondent number 2 is the principal of University Law College,
Respondent number 3 is already served.
my lord, Bar Council of India,
Respondent number 1, 2, and 4.
my lord.
They have not been served.
2, 4, and
2, 4, and 5, sorry.
AD card has not been returned back, my lord, as yet. AD card has not been returned as yet, my lord. So some time will be required, my lord.
Await return of notices of the respondent number 2, 4, and 5 for 2 more weeks. Just after 2 weeks. What, who are appearing on the, whatever the,
Most of
get their notice.
Item 6.
I'm the respondent chain, Lordship. And
Respondent
they have been
number,
directed to take steps.
respondent number you are appearing for?
Chain, Lordship.
Who is appearing for the appellant?
Lordship has last occasion directed to take steps to the appellant.
Who is appearing for the appellant?
Lordship. Appeal. S. Chaudhary. S. Chaudhary, Lordship.
S. Chaudhary, on last occasion also none was present. Inform him if it is available. Pass over for the time being.
Item 7.
May I please, Lordship?
Anyone is appearing on behalf of the sole respondent. Which is this department?
Mr. Khatanier? Who is the Director Secretary Education at this stage?
Momota Huzai.
So notice served, she has not appeared. Personal appearance the way out now.
Malab, will may give me 1 day time, Malab. I will inform her.
Despite service of notice upon the sole respondent, none is appearing on behalf of her. Mr. So
NJ Khatunier.
NJ Khatanier.
India Katuria, appearing for the education department. Raised a week's time to complete his instructions. If nobody, if no one appear, if no one appears on behalf of the respondent number 1, sole respondent on the next date of hearing, will be forced to summon her before this court. Staff ready.
Item 8.
By showing the name of Mr. NJ Khatanier.
May I please, your Lordship. Lordship, the office note indicates that the respondents have been duly served with the notices. So my learned friend is here for the respondent number 2.
Is only for the respondent number 2.
Only for the respondent order. I pray for 3 weeks time to file my affidavit matter. In fact, we have
What about
complied the order.
What about the other respondents?
Others as well, last reason it was not served, my lord. Respondent number 1.
No, it has been served and he has written a letter to the register. How can a
No,
IAS
then,
officer do
then
this?
that cannot be, my lord. You have to engage in
No,
a
he has
council
to
for
have-
it. He's a deputy commissioner of the city, my lord.
At best, Lordship, personal appearance maybe because if Lordship feels.
My lord, government has got- No, the deputy commissioner.
There is a circular by the chief secretary. In contempt matters, they cannot communicate.
My Lord.
So we'll have to ask him why is.
In fact, in my one occasion, when the person who had written the letter was called before the court for writing this kind of letter.
My Lord, I maybe take instruction, my Lord, perhaps, my Lord.
Where is the need of instruction?
What is that?
Call this
Perhaps,
officer
my
here.
Lord, she is not aware about
Why she is not
Yeah.
aware? Why she is not aware?
He.
He or she, whatever, whoever it may be. Why is not aware? Okay. Notices to the respondents are already served in this contempt petition. Mr. So-and-so put an appearance on behalf of the respondent number 2. However, despite service of notice, no one is appearing on behalf of the respondent number 1. Instead, the respondent number 1 has written a letter to the registrar, Guwahati High Court dated 20th of March 2024. Submitting parawise comment to the contempt petition. Full stop. A contender impleaded as party respondent in the contempt petition is not supposed to communicate directly with the High Court. With the registry of the High Court. The proper course for the contender is to appear before the court either personally or through counsel and then to submit response to the contempt petition. Full stop. The respondent number 1 is IAS officer working as District Commissioner, Kamrup Metropolitan District, Guwahati. And therefore, it cannot be assumed that that he is not aware about the procedure. Full stop. Taking into consideration the fact situation, we direct the respondent number 1 to appear before this court personally on the next date of hearing. List on 13th May. Copy of this order be communicated to the respondent number 1.
Item number 9.
The instructions are for my lord regarding release.
Here I pay for another 2 weeks time, my lord.
Why?
That, my lord, verification report is awaited from the district authorities. Direction was that, my lord, to see, my lord, another 2 weeks, my lord.
Page 20, paragraph 20, my lord.
Whether the petitioner has worked, my lord, from the day when the termination order was issued till the service of that particular termination order to the petitioner. 2 weeks, yes.
Page 20, paragraph 20, my lord, relevant portion. Because termination order set aside, my lord, that was my lord, not.
The services will not dispense with either liberties granted by the appropriate representation for any financial termination. It may be entitled to provide this order is dated.
That was my lord, it was passed. My lord, 21/4/22.
2 years.
Thereafter,
Almost 2 years of passed. And still you are seeking 2 weeks time.
My lord, very last month, my lord.
No, nothing.
No, my lord, here may I, my lord, point out one thing, my lord, one technical issue. So far as the respondent in the, my lord, contempt petition is concerned, he was the director in 2015. This petition was filed in 2021, disposed in 22. So present director is taking up the issue, my lord.
When?
My lord,
How is taking up the issue for 2 years? What they were doing?
No, my
What the
lord.
directors were doing?
That,
This can't be taken as like.
my lord, as a last one, Lordship may give a, my lord, opportunity, my lord, for at least 2 weeks, my lord, as a last one, Lordship may indicate in the order. At least I will
This is the
communicate to
last
the present
opportunity
director.
of only a week, not more than that. Mr. B. Gogoi, appearing for the Director of Health Services, raise some more time to obtain instruction whether the representation filed by the petitioner has been decided by a speaking order or not as directed by this court earlier. Full stop. It is noticed that on 4/4/2024, time was granted to the learned counsel for Director of Health Services to ascertain whether the representation filed by the petitioner has been decided or not. It is very sorry state of affairs that this order by order, this court by order dated 21/4/2022 issued a direction to the director of health services to decide the representation filed by the petitioner by a speaking order. But despite passing of around 2 years, till date, the representation of the petitioner has not been decided. Stop. In the interest of justice, last opportunity is granted to the counsel appearing for the Director of Health Services Assam, either to comply with the order or to face consequences. This matter on 1st of May 2020.
Last opportunity to the director, madam. To the director, not to the council, madam.
Director.
Oblige, sir.
Item 10,
My lords, may kindly peruse the last order dated 10th of April, my lords. The CPWD was, we have submitted the value. We have received, my lord, we have submitted to the arbitrator, my lord. We have received the report and it has been submitted to the arbitrator. my lord.
Now what remains in this matter?
Nothing, my lord. My lord, this copy of the valuation report may be furnished to us, my lord, because our land has been acquired, my lord.
You are the person, your land is
Acquired, my lord. Yes, my lord. It's my house, my lord, which has been valuation has been made, my lord. In fact, this may be furnished to us, my lord. Secondly, my lord, since my lord, this report has already been submitted before the arbitrator, my lord. So may I say, my lord, if lordship may kindly fix a date in the arbitration proceeding, my lord, so it may proceed, my lord, now.
That is for the arbitrator to decide, sir. How we ask the arbitrator to fix a date. That is for the arbitrator to
Yes.
decide.
Our
That is not for this court.
is the copy may be furnished. Copy the begin. What do you think?
Be careful. Learned counsel appearing for the CPWD has informed that the CPWD has already prepared the valuation report and has submitted it before the arbitrator.
They have submitted it. You have submitted it to.
We have received from them, we have submitted before the arbitrator.
Has already and they submitted it to the NHAI. Full stop. Learned counsel appearing for the NHAI has submitted that the said valuation report has already been submitted before the arbitrator who is seized of the matter. Full stop. Learned counsel appearing for the respondent number. For the private respondent has submitted that the copy of the valuation report is supplied to him so that the private respondents may place their case before the arbitrator. So, taking arbitrator. Full stop. Learned counsel appearing for the NHA is directed to supply a copy of the valuation report to the counsel for the private respondents during the course of the day. Abhi de de,
Well, 1 day may be given, my lord.
within a period of 2 days. Full stop. Taking into consideration the fact that CPWD has already prepared the valuation report and submitted it to the NHA, no further order is required to be passed in this.
This order is complied with, my lord, 28/9/23, my lord. We may proceed with the work, my lord. That is very crucial, my lord.
They want the order to be before vacating and proceeding the valuation report. You want this interim order to be vacated?
Yes, my lord.
In now since the relevant data is available. There is no impediment.
In view of the fact that the valuation report has already been prepared by the CPWD and has submitted to the NHAI, who in turn has submitted it before the arbitrator for fixing the compensation, for determining the compensation to be paid to the respondent, to the private respondents. We are of the view that no further order is required to be passed in this petition, in this IA.
This order is being written.
We are of the view that the order passed by
Order dated 20.
order dated 28/9,
Ask to be dated
2023, passed in writ appeal number 375, only 2023, is hereby vacated, and the NHAI is free to proceed forthwith with the construction and removal of structures and trees, crops, plants of the opposite party number 124. By removing structure and trees slash crops slash plants of the opposite party number 124. I stand.
Item 11.
The affidavit has not been filed on last 3 occasions.
My lord, I have received some instruction. Matter may be taken on day after tomorrow or Thursday, my lord, on the basis of that instance.
Okay, then counsel appealing for the respondent pays 3 days time to file counter affidavit, time paid for his separate.
Yes, my lord.
Item 12.
My lord, in this matter, we have taken steps, my lord, through paper publication upon the respondents, my lord. And we have filed an affidavit to that effect also.
Paper publication is already there. Nobody is appealing on behalf of.
My lord, I have been informed, Lord, that M. Chanda, my lord, he would be appearing, my lord. I was M. Chanda, M. Chanda, my lord. He has requested extra copies from me, my lord, yesterday.
You inform or will pass it over for the time.
My lord, my lord.
Item 14.
May it please, Your Lordship. In the last occasion, lawsuit directed the authority to may furnish the list of beneficiary and the mode and basis for payment of compensation.
Yes,
Lordship, today we have filed our affidavit, Lordship.
today you have.
Lordship, we have already
List
served.
of that copy.
Today they furnished just now, my lord. But my lord, there are certain discrepancy I found, my lord. Can it be taken? Because they have not taken care of our rights.
Okay, you file your objections, whatever.
Can it be taken on 3rd of May, my lord? For further hearing.
Take your own time. What's the problem?
My lord, they have not filed till now, my lord.
London council appealing for the.
We have filed.
NC Hills Authority Council has filed, has submitted that he has filed affidavit pursuant to the direction given by this court on 4/4/2024 today itself. London council appealing for the petitioner is in receipt of the said affidavit. However, he placed some time to file counter to the said affidavit based on.
Second week of May, my lord, any date, my lord.
Sole respondent, returnable, sole respondent,
No, my lord.
to the respondents,
Respondent.
returnable. 3 weeks registered in.
Machal.
Item 15.
Lordship, notice has been sent only on 18/4, Lordship. So service report may be awaited, Lordship.
My lord, I appear for respondent 1 and 2.
How many respondents are there?
Three, Lordship. Notice has been taken on respondent number 3, Lordship.
Only respondent number, only one respondent.
No,
That's-
3. My friend appear for 1 and 2, Lordship.
And there are 3 respondents in all.
Yes, Lordship.
Okay. Await return of notice of respondent number 3. List after 2 weeks before the Laulima court to ascertain the service of notice upon the respondent number 3.
Item 16.
May it please, your lordship. May it please, your lordship. So in terms of lordship's observation at page 17, lordship, para 16, lordship, para 16, page 17, para.
Does the explanation to give preference to the while making any fresh structure on the post of daily window work done and next floor.
So file the representation before the authority lordship. Page
Who is the person who is supposed to comply with the direction?
Yes, sir, he's the chief manager, lordship,
Who is the chief manager?
manager of APDCL.
Who is the chief manager?
Uh,
Why you are not named? You have to make him party
yes,
first,
yes,
by,
by name.
where is the name?
Uh, will collect.
Whether they have appointed any person on daily wages or work charge?
Yes, already lordship, December 2023, they have published some outsourced people lordship. But name of the applicant has
May
not
so-
been added.
You will have to demand compliance of the order from the right authority,
Yes, lordship.
and then only you can implement him.
Yes, lord.
So you first do all these things. It will take time.
When you have approached the respondents that this is the order. passed in
Yes,
your
on
favor
1st
and
January 2024, page 31, lordship.
So you approach them on
1st January 2024.
1st January 2024, whereas we are relying on an order of 2nd of December 2023.
And
So
before
if you
also,
have not approached them,
before also, lordship, before also we have approached to the chairman. Before also we have approached, page
this
28 is the,
petition is filed by
page
the-
28.
filed by the petitioner alleging non-compliance of the order passed by this court. The petitioner has not included the person who has willfully disobeyed the order passed by this court and has simply included the office of the Chief General Manager, Assam Power Distribution Corporation as respondent number 1. Then it concept of the petitioner pays time to include the proper person as a respondent in this contempt petition. Time frame for his granted after 3 weeks.
Deeply obliged.
Item 17.
May I please, your lordship, matter may be adjourned today. I guess council is out of session.
Steps. You have not taken any steps.
Lordship, I have not, don't know about the case.
Do not
In the
know what
morning,
to do.
in the morning, lordship, they told me about the case and
ask the council that you have to take steps.
In fact, all the respondents are my official respondents.
So you are appearing?
Yes, ma'am.
Okay.
Except respondent number 3, madam.
Then why accept response number 3 appear for all the respondents?
Three is the deputy commissioner, madam. Oh,
Respondent number 3 is district level committee, DLC chairman and deputy commissioner.
deputy commissioner. I will plain will appear, madam. For the others, I will appear.
When council for the petitioner is directed to take steps for service of notice upon the respondent number 3 as directed by this court order 9/2/2024 within a period of 1 week.
I may appear on behalf of respondent number 3, copy of the petition to be served.
As per the office report, no steps for the issuance of notice of application under section 5, the limitation it has been taken by the council for the applicant. Mr. So-and-so is appearing on behalf of the respondent number 3 and Mr. So-and-so is appearing on behalf of the remaining respondents. Service is therefore complete. Copy of the application be supplied to them within a period of 1 week. Response to the IAB file 2 weeks thereafter.
DK Sharma for 1 and 3, and J Khatunia for remaining respondents.
For admission, item 18 and 19.
May it please your lordship. This matter be taken up on Thursday on a hearing day, lordship. I'm in the midst of two part-heard matters in other courses. Then let no.
Taking it as a.
The other day I was fully prepared. I'll do it, lordship. No difficulty.
No, we don't have any
No, I have.
problem in adjourning the matter. But what remains in this matter now? Please comply with the order and proceed with
No,
the
lordship,
inquiry.
if lordship finally decides we have to comply, we'll definitely comply, but we'll explore all our legal remedies.
But here you are exploring.
Legal remedies we'll explore. Thereafter, yesterday what happened, lordship? Another case that lordship was dealing with the other case regarding the MP. For last 10 years, he availed the opportunity of getting the MP's position on the basis of SCP as the same person after.
Depends upon facts.
Absolutely. How they are playing with the authorities.
Here if you are agreed by that her this certificate is whatever the certificate STP or tribe certificate is not in accordance with law. You can initiate the proceedings.
No, we have already initiated.
Lordship
Lordship has stopped it. Otherwise, we have initiated. We'd have completed it also.
Madhuri Patel's case, you comply with that, but.
We have complied with Madhuri Patil's case. Then we found that our whole inquiry was perfunctory. Then we started a fresh procedure. We issued show cause notice and honorable court, this court said that stop for the time being.
Till that inquiry is completed, you comply.
We could have completed in 10 days time if they have cooperated. Otherwise. In fact, lordship, it was not our case to stop her from working. There was complaint and complaint was dealt with.
This is now about suspension, reinstatement.
It is not on suspension.
Reinstatement.
Reinstatement. She was working for 3 years. The complaint came. It was inquired. The inquiry was totally perfunctory. That report was submitted and this honorable court rightly set aside the cancellation order. Then when we wanted to comply with the direction of this honorable court, we looked into it. Who was at fault? Because 2 reports were before the government. One was by the deputy commissioner's report, as well as the other report from the state levels scrutiny committee. The vigilance officer's report is totally in contradiction to the deputy commissioner's office. Then the government decided that whether our police officials have rightly done it or not. Then the report came. The SP was not at fault. The officer who was at the ground level, he gave a report which is totally not in compliance with Madhuri Patil. When these findings came out, we complied a detailed report and submitted before this honorable court in our review application, whether we can go ahead or not. what we have said in our review application, that kindly give us 15 days time, we'll complete the investigation.
Mr. Sekar, these are all fine. There's no difficulty. At the moment, the issue before the court is whether she should be reinstated immediately, and you carry on with your inquiry and take whatever step.
When it is found that she is not a OPC,
Sir, at the time when this division bench has decided the matter, this report was not there.
this report was not there.
Then what's wrong in this?
That
order?
is why we have filed review. Under what ground the review is
Scope of review is very limited.
very
sir.
limited, I will place the Supreme Court judgment as
What is the basis of the review?
If some,
My learned friends advice.
some evidence.
why he is interfering, Lordship.
You have gathered some material after passing of this order. then
No,
how can
Lordship,
this order be
if
found
Lordship
to be
finds, that there is no ground of review, Lordship has every right to dismiss my review. But Lordship will have to hear it.
Okay, fine. Tomorrow, if you are busy.
No, either today or Thursday, Lordship.
today,
Tomorrow I have NGT's matter, Lordship. I want to argue.
After lunch. If you are-
Tomorrow after lunch, Lordship.
Tomorrow
After lunch. At 2 o'clock, Lordship.
Tomorrow, we'll fix it tomorrow at 2 o'clock. We'll take up the matter at 2 o'clock.
Lordship. I'll prepare written things also, Lordship, so that it will be convenient.
Item 20.
Tomorrow at 2. Tomorrow, रख दो. 2 पे, understanding है, we'll take it. Yes. They've already get this whatever degree you are having compared, and the expert committee has considered the matter and found that it is not equivalent.
My lord, Mr. B. Professor is appearing this matter, my lord. Can it be after some time, my lord? He is in other courts in Lake, my lord, in courtroom number 26.
Also the timing.
Deeply obliged, my lord.
Item 22.
There is.
May I please, Lordship?
Item 20.
The appellants were respondent number 7 and 8 before in the writ petition, Lordship. And the impugned order has been passed affecting their fishing right, Lordship. Impugned order is page 20, Lordship.
This is
22.
22.
Without permission. No, there may entry more than.
As page 20, Lordship, impugned order. The main discussion is paragraph 9 at page 26, Lordship.
Yes.
May I please read, Lordship?
Yeah.
In the backdrop of the above pleadings, this court has also heard the learned counsels for the petitioner as well as the respondents. From a perusal of the writ petition and more particularly the impugned order dated 29/6/2020, it is seen that the same was passed in a whimsical manner without taking into consideration the facts in its proper perspective. It further transpires from a perusal of the impugned order that though the respondent number 4 had duly taken note that the respondent number 7 and 8 had violated the terms and conditions of the permission to catch fish accorded in the 2002, but still opined that as the respondent number 7 and 8 were representing the Mohal numbers 8, 9, and 10 of the second class fishery, and they got the Mohals on recommendation of the erstwhile fishery minister as well as the order passed by this court, they should also be made representatives of Mohal number 8 and 9. The basis on which the settlement officer had come to its opinion in passing the order, in the opinion of this court, is not tenable and reflects the arbitrariness and in exercising the power by the settlement officer, in as much as the settlement which was granted to the respondent number 7, 8 were subject to certain terms and conditions, which admittedly, as could be seen from the perusal of the impugned order itself, was violated by the respondent number 7 and 8, merely because of the fact that the settlement was made on the recommendation of the erstwhile minister of the fishery, and thereupon the respondent number 7 and 8 were allowed to represent the Mohal number 8, 9, and 10 of the second class fishery, would not absolve the respondent number 7 and 8 to continue with the right to represent the said Mohals without adhering to the terms and conditions of the order dated 23/9/2002. Further, that this court has also perused the order of this court, reference to which was made in the impugned order dated 29/6/2020. The said order has been enclosed as annexed 2 to the writ petition. From a perusal of the said order dated 24/4/2002 passed in WPC number 7659/2001, it reveals that this court had directed the settlement officer, Kachar and Hailakandi district, that is the respondent number 4 in the year 2002, to examine the representation submitted by the respondent number 7 and 8, and thereupon grant the necessary permissions. The said order not in any manner direct granting of settlement in favor of the respondent number 7 and 8, but only directed examination. Further to that, even assuming that the order had directed that the respondent number 7 and 8 be granted the permission, then also such permission has to be understood to be subject to the terms and conditions of the permission, which admittedly have been violated by the respondent number 7 and 8. Under such circumstances, in the opinion of this court, the impugned order dated 29/6/2020 suffers from gross arbitrariness, unreasonableness, as well as appears to have been infected with the abuse of the powers conferred upon the authorities. For the said reasons assigned above, this court therefore set aside the impugned order dated 29/6/2020 passed by the respondent number 4.
What is that order 29?
6/2020, Lordship, at page 66. Now it refers to, Lordship, only one
Where is the court's order?
Lordship,
Court's order,
court's order.
earlier court's order.
Page 46, Lordship.
pursuant to this court order, there is the order of this granting fishery right to you.
Lordship, to the appellant number 1, not in pursuant to this court order. This is it is referred in this court order, this letter, this settlement order dated 1/8/2001, CSO 95 of 2001. It is, this is page 47. In the High Court order, it is there.
This is the page 47, but where is the settlement order?
This settlement order is at page 90, Lordship,
90.
90. This is a part of my affidavit in opposition, our affidavit in opposition. This is in respect of appellant number 1 only, Lordship.
Okay.
Now, Lordship, in this order dated 29/6/2020, the violation has been referred to the order dated 29/2002.
26?
23/9/2002. At page 66, the violated the terms and condition imposed by this office order dated 23/9/2002, but violated the condition. Third paragraph, Lordship.
Yes.
23/9/2002. The 23/9/2002 order is at page 50.
Read.
Lordship. Paragraph, third paragraph, Lordship. Peruse the report submitted by ASO Katigora by this letter.
Page
66.
66 is something else.
It was the impugned order that was set aside.
Peruse the report submitted by the ASO, this one.
Yes.
Yeah.
Their reference in the 5th line, Lordship. Terms and condition dated 23/9/2002.
Yes.
Now, this 23/9/2002 is at page 49.
Yes.
This is in respect of, there is fishery mohal number 8 and 10. And in the name of Nurul Haq Borbuya, his appellant number 2, there is respondent number 8 before the learned single judge. It petition. So in respect of respondent number, this is 7, there is appellant number 1. It could not have been set aside because violation was indicated only to this. And it is in respect of this Nurul Haq Borbuya. This is appellant number 2 before your Lordship.
And why you have filed this combined appeal?
Lordship, because the affidavit in opposition was filed jointly and
Only you are claiming only for the appellant number 2, not for appellant number 1.
appellant 1 also, Lordship.
What is the case of 1?
This is a case of 1 that there is no
and
violation.
the appellant number 2.
And then appellant number 2, Lordship, they were settled in the 2000, of course, 2002. He was settled in 2002, appellant number 2. This landlocked, the second class fishery is, these are wetland, Lordship. Wetland, as per rule 14 of the Kachar, this is Assam fishery rules. May I please refer to this rule, Lordship? How settlements of fishery is made. Number 1.
Yes.
May I please read it, Lordship, for a while. Settlement of fisheries as land. Fisheries cannot be settled as land. In Kachar, however, small, that is second class fisheries which adjoin settled land shall be entered in a separate register in the Deputy Commissioner's office and not included in the ordinary Jamabandis. The lease for such fisheries is in special form sanctioned at the time of resettlement. Fisheries which have splitted up shall be settled as wasteland and the ordinary rules. As by the terms of the lease, the rights of the lease extend to fishing only. They cannot acquire the status of landholder. Now, these, they were in my affidavit in opposition, we have specifically stated page 70, it is the affidavit in opposition. Page
Yes.
Page 79, paragraph 2, Lordship. May I please read, Lordship? That before making Parawa's reply to the amendments made in the instant writ petition, the deponent begs to state the brief facts which may be relevant for proper adjudication of the instant writ petition. The respondent number 7 and 8 are the great grandsons of the Chandumiya. Chandumiya had 6 sons, including Moti Raja and Arjan Ali. The respondent number 7, that is Abdul Handan Barbuya, is the grandson of late Moti Raja through his son Khalilur Rahman. The deponent respondent 8, that is Nurul Haq Barbuya, is the grandson of the late Arjan Ali through his son Abdul Sattar. As such, fathers of both respondents 7 and 8 were cousin brothers. The landed properties left by late Chandumiya were gradually developed upon his heirs, and at present, the present respondent number 7 and 8 are occupying their respective shares along with other legal heirs of late Chandumiya. There are 3 second-class fisheries, namely Donopara Chiruamal number 8, Harbalkhal Mahal number 9, Uttaya Mahal number 10. All the aforesaid 3 fisheries are the subject matter of the present petition. The aforesaid 3 fisheries, that is second-class fisheries, are surrounded by the land which originally belonged to the late Chandumiya, and the same has now been inherited by the present respondent number 7 and 8 as the legal heirs of the late Chandumiya, along with other legal heirs. As the aforesaid 3 fisheries are second-class fisheries, and since the same can be settled with anyone as per provisions of the Assam Fisheries Rules 1953, the predecessor of the respondent 7 and 8 were given settlement of all the 3 fisheries, and they were paying the annual rent as fixed by the competent authorities from time to time. Now,
Yes.
then F, Lordship. After the death of predecessor of the respondent number 7 and 8, the Harbalkal Mahal number 9 was allotted in favor of the present respondent number 7 by the order dated 1/8/2001 issued by the settlement officer. Similarly, by another order dated 23/9/2002, the Donupara Chirua Mahal number 8 and the Uttaya Mahal number 10 were allotted in favor of the present respondent number 8. Having been, paragraph G, having been allotted the fishing rights over the aforesaid 3 mahals by the aforesaid orders dated 1/8/2001 and 13/9/2022, the respondent number 7 and 8 were occupying the respective fisheries by paying the revenue time to time without any fault as fixed by the authorities. The aforesaid settlements were renewed in every year on the prayers of the beneficiaries. There is the respondent number 7 and 8. Under such circumstances, a complaint was filed by one Ilyas Ali against the respondent 7 and 8, which was registered as miscase number 1 of 2007. And the settlement was by his order dated 23/2007 disposed of the case, holding the respondent 7 and 8 representative of the Mahal number 8, 9, 10, and have been paying government revenues regularly as fixed. What I'm trying to emphasize, Lordship,
What is the, this report dated 4/12/2019?
4/12.
By respondent number 5?
Yes, it is there. Page 65.
What is the annexure 7 to the petition?
Annexure 7 to the writ petition. It is our application.
Your
What happened, Lordship, before that?
Just the-
Page 59. Lordship. What I'm trying to emphasize, Lordship, as per this rule 14, the lease for such fisheries is in special form sanctioned at the time of resettlement. Our specific case before the Honorable Single Judge was that since the time of our father, it was settled to us. Thereafter, in 2002,
Both are brothers, 7 and 8 are both brothers,
they're cousins, Lordship. They are cousins.
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 But you are heirs of that Chandu Miya,
Yes. Heirs of
legal heirs of Chandu Miya.
Tandumia. And there is a register, copy of register, it was annexed to the writ petition. It also shows the name of my father. My father. So as per this rule 14, it is to be, settlement is to be given at the time of resettlement.
You have violated the conditions or not? The conditions of allotment.
That is the allegation, counsel.
That is the allegation, then what remains? You violated the conditions. The fishery was settled in your favor on certain conditions and you violated the condition. Despite that, you were granted favor.
What happened, Lordship? We regularly paid this revenue, but these documents could not be produced before this in the writ petition with the affidavit of
Then you have to suppress it.
Then they have to find a reason.
And in the appeal memo, Lordship, I have prayed for leave to file these the additional documents, Lordship.
But these documents were certainly not before the learned single judge.
Yes.
How can we consider these documents here? Then what's wrong in the judgment of the learned single judge?
So far as the appellant number 1, there is no violation, Lordship.
Whatever it may be, you have some documents that you have not violated the terms and conditions. The learned single judge was mainly influenced by this fact that though you have violated the these conditions of your allotment, despite that, who are the officer concerned has granted relief to you. Why?
But this could not have before appellant number 1, Lordship, because there is no violation for appellant number 1.
The combined reading is there. Both of you were violated.
The violation in reference to order, the settlement order dated
Maybe, sir. This is the
23/9/2002. It is mentioned in
have you
page.
filed a combined reply to the writ petition.
Yes. Comment reply. Page 26, Lordship, it has been mentioned.
You want to rely on those documents which now you are relying, file a review petition. This is what, though it is not an advisory jurisdiction, but can be to. If not.
That liberty may be given. That liberty may be given because limitation.
And consider the appellant after attempting to argue the matter for quite some time, and counsel for the appellant had submitted that he wants to withdraw this petition with liberty to file writ appeal with liberty to file review petition before the learned single judge, dismissed with liberty as prayed for.
Lordship, please, additional documents, this part may be.
Whatever you want, review if
Obliged.
court permits in accordance with law, you may do it.
Obliged.
You are on caveat.
Yes, in fact.
Caveat standard.
Item 25. The appeal has come for admission, right?
Similar appeals are.
Similar appeals are lordship admitted, madam. I have the order, madam.
You are appealing for the respondents. Then counsel for the appellant has submitted that. The appeals involving identical issue has already been admitted by this court. Admit counsel appearing for the respondent number for the sole respondent.
No. Gotcha. The others are perform, my lord.
For the respondent number 1, accept notice, Mr. So and so accept notice on behalf of the respondent number 1. Others are perform on respondents. Hence, service is complete. List along with writ appeal number 50/2024.
Lordship. Item 26.
Well, this matter pertains to non-payment of pension, and the first wife is the appellant herein. The second wife filed a writ petition claiming pension on behalf of her minor child. And the learned single judge, while disposing of the writ petition, directed the authority to determine the status of the minor child and the appellant herein.
Last time we granted time to whether this order has been complied with or not.
In compliance of the order dated 23/2/2024, Agriculture Department has sent a pension proposal to the accountant general.
Accountant General is party in this proceeding.
Yes, sir. Yes.
जी का भी
Agriculture Department has sent the proposal to the Accountant General, and now the Accountant General will
But the consideration was already made before, my lord, before filing the writ petition. But by of a interim order passed by this honorable court, the payment was stopped, my lord. If I may take your lordship to page 100 of my writ appeal.
yes.
This is a subject stop payment of family pension in respect of Srimati Bulumai Mohanto, that is the writ appellant herein. References Honorable Guwahati High Court interim order dated 2/1/2023 under WBC number so and so in the matter of Srimati Purabi Saikya Mohanto. Sir, in inviting a reference to the office PPO number so and so issued in favor of Srimati Bulumai Mohanto, first wife of late Niripan Mohanto, Executive Deputy Director of Agriculture, white letter number so and so. I am to state that as per the Honorable Guwahati High Court interim order dated 2/1/2023, it is requested to stop payment to Srimati Bulumai Mohanto until further orders. The process was already started, my lord, and the interim order your lordship will find at page 93.
But now this interim order came to an end with the decision of the writ petition.
Yes, my lord. But the decision is, my lord, it has been directed to the authorities to ascertain as to whether the second child through the second wife is entitled or not. But we are not disputing that. But they are entitled. The only direction, my lord, ought to have been directing the respondents to disburse the family pension in favor of the first wife after obtaining an indemnity bond. As per the indemnity bond, as per the rule, my lord, she will share the part of pension with the second wife's, my lord, daughter. And the full bench judgment also, my lord, of this honorable court, it has been made clear that for any dispute regarding family pension, my lord, they should approach the appropriate forum by of an appropriate application. And the writ court may not like to decide, my lord, the quantum of pension to be payable or the share of the amount to be payable to the second wife.
My lord,
Yes.
I'm appearing on behalf of Accountant General, my lord. I received a letter from Principal Accountant General that we have not received any information from the concerned department. Now my learned candidate said that it was sent on 18th. Today might have got it, and I will accordingly will act upon that. Within 7 days, we'll act upon that. That's my estimate on behalf of Principal. Immediately.
Full bench or decision it was.
Mr.
C. Baru.
C. Barua,
Appearing on behalf of.
standing counsel for AG A&D, has submitted that the proposal for the agriculture department has already been received by the office of the accountant general.
I have not received so far. 19 letter says, now as soon as today I confirm Miller and I send it by this one today. Because my letter said you have not received none after 19.
The council
My
appearing for the
submission we are
agriculture
awaiting.
department has submitted that the proposal regarding pension, the case of the appellant as well as the private respondent has already been sent to the accountant general Assam. Learned counsel, Mr. C. Burwa, standing counsel, accountant general Assam has submitted that he has just now informed that the proposal has been sent by the agriculture department. He submits that a week's time be granted to ascertain whether the accountant general has acted as per the proposal sent by the agriculture department or not. List on 3rd of May. 3rd of May.
Obliged.
Item 27.
May I please, Your Lordship, this is a matter arising out of a order passed by the Central Administrative Tribunal. The matter has a checkered history, my lord. This is when BSNL was created on 1st of October 2000 from the erstwhile Department of Telecommunication. The ZPF scheme was discontinued and we had switched to the EPF scheme. What had happened is that, my lord, at that point of time, my lord,
Registered AD,
deeply obliged.
6 weeks.
29.
Yeah, that's it. I don't matter relating to my lord, anomalies of the ROP, 2017. May I lord, kindly have a look, my lord. The order dated 4/10/2023, my lord. And have a look, this is the, this order, my lord. 4/10/2023, my lord.
1910.
My lord. Order dated 4/10/2023, my lord. Can you have a look, my lord?
4/10.
2023, my lord. Or a detailed discussion as one of Indian order, my lord. Now the respondent has submitted a new new rules, draft rules is preparing, my lord. My lord, my case is not under draft rule, my lord. My case is, my lord, I am seeking my benefit from the Assam service nursing to 1990, not my draft rule. In the 1990, page 33, my lord.
No, on the last occasion, it was informed that whatever the grievance of this appellant is there
Madam.
or petitioner,
Still, madam,
that would be resolved by the draft rule of Assam Nursing Service Rules 2023.
madam.
What they are saying.
My case is not the draft rule. My rules is 1991. My push is still in India. There is a push name called staff nurse. Page 13, page 33. I am not on the draft rule.
You are the diploma holders.
No, kindly have a look at page 33. These are rules from 1991 rules, page 33. There is a push, it is called staff nurse.
In that draft service rule, my lord, there is a distinction between diploma holder and PhD degree.
In 1991 rules, there is no difference.
2017, my lord. The anomalies cannot meet up then, my lord.
Division of
But
payments.
these draft rules, my lord, their submission was made.
So every time. case get revised.
But their submission was made on earlier occasions and learned single judge, my lord,
If
on order
the
dated
rules
14th.
don't make a distinction, where is the rationale behind having a distinction in the ROP? ROP
That is my
cannot
case, my
run
lord.
counter to the
These
rules.
are ROP, my lord. Can you believe it?
And subsequently after the ROP, my
No,
lord,
if you agree, if you concede, then we'll,
They agreed, my lord. They
You are
filed an
agreeing
affidavit,
that?
my lord.
we have filed affidavit, my lord.
you're conceding to his point.
Yes,
My lord. They filed an affidavit, my lord.
affidavit dated 23 to 2023.
Page 53, my lord. Page 53.
Which para?
My lord, page 53, paragraph 6, my lord.
6 or 8, 6.
6 and 8 both, my lord.
6 and 8. They agreed.
Let's see. Yeah, the family welfare concept. Is it- Yeah. The disparity. This is.
Will record your statement.
Even at 2010 ROP, my lord, there is no distinction.
No, will record your statement that the government is agreeing that there is a disparity between the pay scales, though their work is the same. And you have already sent the matter to and the matter is at the end of the finance department. This is what your submission is.
Yes, my lord. On last occasion, today, my lord, there is a communication from the finance department that the file has been returned back to the health and family welfare department with certain observation to meet up. Today,
No, maybe you take, will record your statement in the
affidavit.
this affidavit and take a decision within a period of 3 months, 90 days. Yes.
My lord. My lord, we are, my lord, now serving, my lord, without any push, my lord. My lord, we are getting only, my lord, 6,800, my lord, basic pay, my lord. Now, the basic staff, my lord, they are getting, my lord, 8,700. Get pay, my lord.
So you want the same pay
Same pay.
for
Same
BSc and diploma, it should be same pay.
Right.
So that is the accepted stand of the government.
They accepted by the government.
But the ROP rules provides a distinction.
My lord. Only ROP 2017. ROP 2010, my lord, there is no distinction.
In the draft service rule also, that distinction is not there, sir.
This ROP, my lord,
This direction is already issued by this court on 4/10/2020.
2010, my lord.
What you are doing now?
Now, my lord, they are saying they are preparing draft rules for something else, my lord. That draft rule, that submission already rejected by the, my lord, Honorable Singh. Even they accepted that there may not be.
Why this matter has been listed before division bench?
Because of the rule, my lord.
There is a single phase order, my lord.
Initially, it was before the honorable single, but because of the issue of draft service rule, my lord, probably that's the.
Draft service rules, they are not under challenge.
No, not on the same.
Then why?
Well, on that particular date, my lord, Honorable Singh Das, my lord, taken up the matter relating to pension, my lord, pension matters, my lord. And this matter, my lord, listed before the Honorable Court, my lord. And my lord, Honorable Singh Das passed an order.
But this matter is listed before this court. By what order?
4/1/2000.
ROP rules are delegated legislation. Sorry? 309. So these rules will have to be read down then.
1991 also made by the petition.
Mr. Nayak. The department has in a way considered their stand that there is no scope of any distinction. The affidavit also says it will be one pay scale. That's right, that's right.
And the department was to formulate the rule as per the rules formulated by the ROP. That formulation is going on. So it is the stand of.
So they will continue with the distinction.
Yes, finance department, the stand of the finance department. Diploma holder must be
But the parent rules don't make a distinction.
That is why not in the ROP itself that concerned department to formulate as per the that process is today my friend does not. Observing some observation. The department. Or we allow sometime.
Even my new advertisement, my lord.
Now, what they changing the rule justified with
Even my new advertisement for the fill up the proofs of staff nurse, my lord. There is no distinction.
that you have mentioned thrice.
Well, even 1990 also, there was no distinction.
You
2000,
have
2000,
mentioned that twice.
This writ petition filed by the association of the nurses, of the staff nurses who are the diploma holders. So their main grievance, the main grievance raised by the members of the petitioner association is that the that though the staff nurse having BSc qualification and the staff nurse, the staff nurse possessing BSc qualification and the staff nurse possessing diploma qualification are doing the same work and
Treated equally under the rule.
treated equally under the rules of 2017. Sorry, 2000, rules of Assam Nursing Rules 1991. The ROP of 2017 made a distinction between the staff nurse possessing BSc and the staff nurse possessing degree, diploma, and
in fixing the grade pay.
in fixing the grade pay. Full stop. It is contended that though the medical and health department, the family welfare and health department has recommended the government to clear this disparity, the government is not taking any steps in this regard. Stop. Affidavit in opposition is filed on behalf of the family welfare and the health department, wherein the claim of the members of the petitioner association is more or less admitted, and it is indicated that the family welfare and health department has already taken, has already decided that the disparity between the grade pay of the staff nurses possessing diploma, possessing BSc certificate and staff nurses possessing diploma should be resolved. Full stop. It is contended that the matter is pending at the level of finance department. Then it counsel appearing for the finance department has submitted that the has submitted that the finance the department is of the view that there is no illegality if there is disparity in the grade pay of the staff nurses possessing BSc and the staff nurses possessing diploma. It is contended that the finance department has already requested has already asked the government to get the Assam Nursing Service Rules 1991 amended as per the provisions of ROP of 2017. To stop, Learned Finance Department has submitted that some query is received on behalf of the Health Department. You are in receipt of some query by the Health Department. The received some query from the Medical and Health Department recently, and therefore he wants to complete his instructions. Time date for is granted. List on so and so. 21st of May.
Item 30.
May I please, your lordship? My lord, an additional affidavit has been filed by the Sarva Shiksha Abhijan Mission, my lord. And wherein, my lord, they have contended that out of, my lord, initially there are 43 points which had been raised by the PAG, my lord. And out of that 43, they have responded, my lord, and 22 charges had been dropped. Now the remaining 22 is still there, my lord. Now, what is the status of that, my lord? My respected friend can apprise my lordship, my lord.
They have already filed an affidavit on 5/2/2024.
One additional affidavit has also been filed now. There we have
When?
to record another 3.
So what about the other objection?
I have mentioned in my affidavit that in respect of the remaining allegations are also communications between the CAG and the department is going on lot. And we are trying to settle those. These are basically queries lot. These are not allegations. And second issue is there lot. In the PIL, a prayer has been made to that for a direction for registering a case against the official. Now, my submission will be lot to whether on the basis of a report, CAG report, any offense can be registered or not. That is a legal issue lot. And the Honorable Supreme Court has already passed several directions. Lot. Our High Court also passed directions. It is not permissible.
Only on the basis of the CAG queries, no.
These are basically properties of the legislature or parliament law. So until and unless they took a decision law, it is not in the public domain. That is the stand. It's the stand. My submission will be lot.
So, Mr. Bhuya,
My-
have you got the affidavit dated 2/3/2024?
2-3 years, yes, my lord.
Any response is required? Rejoinder is required to file?
No, my lord, rejoinder because they have communicated and the charges had been dropped by the comptroller and auditor general.
Then
my
we'll
lord.
close it.
Then, my lord, there is a similar direction had been passed by this honorable court, my lord, by basing relying on Article 149, my lord. If my lord may be pleased to go through Article 149 and exactly in similar PIs with the other issues.
What direction has been issued?
My lord, direction had been issued that it should be placed, my lord, before the authority under Article 149 and they will, my lord, look into the matter, my lord.
Public accounts.
Public Accounts Committee of
That is
Public Accounts Committee, my lord. In that line, my lord can dispose of, my lord.
why this
বেলেগ এটা দিয়া না হেৰি নাই নেকি দুটা কপি নাই Lord, in Article 150, my lord,
Yes,
my lord.
even though if we pass, no order, direction is passed in this respect, then also they are bound to place it before the.
But they are not, my lord, until and unless, my lord, in the earlier allegations, in earlier PILs, my lord, we came before my lordships, only thereafter, my lord, this order had been issued. Till date, my lord, our instruction is that in those cases also, it had not been placed before the PSC, my lord. It is a mandatory requirement, my lord.
Lordship, in the present case, Lordship, in my earlier affidavit, it will reflect of the first case, first allegation has already been placed before the PAC. That is already there.
What about the other allegation?
Others, Lordship, these are the process of settlement between the PAC and is going on. Thereafter, Lordship 22 has already been dropped.
Okay, then we'll place it after 6 weeks.
My lord.
And in the meantime, you complete your instructions and whether these objections are dropped or any action what you are taking.
Yes, Lordship, definitely. But in my humble understanding, Lordship,
It's after 6 weeks.
What if one order your Lordship will like to take note of? 1/2/2023 law. Judicial order was there, it has not been complied by the petitioner.
1/2/2023.
Yes, sir.
What is this order?
Affidavit. No, we have filed a detailed affidavit.
Here, when concept of the petitioner explain as to whether the bylaws of the petitioner's organization also provide for making inquiry as to whether the how the government permit is placed in what manner.
Lord, we have filed a detailed affidavit, my lord, in compliance with the state order, my lord,
In compliance of this order.
on 27th day of November 2020, my lord, we have brought on record the credentials
It's an
of the.
order of 2023 Lordship. And in last two, my affidavits are after 2022, no, nothing has been filed by the petitioner. But the record is concerned.
Inform this court after 6 weeks.
My lord.
Obliged.
Item 31.
So here, so here I have received the report from the FIC, the field office. This is the status report. But if proceed takes up the affidavit, paragraph 4, the relevant portion is at page 161 in the affidavit. In the PIL, prayer of the petitioner is that the Inquiry Commission report submitted by is to be implemented and that has to be made public. That is their prayer. But in our affidavit of page 161, we have stated that the report of the committee has already been placed before the government, and government has decided to take care of the report and subsequent after a series of meetings were held, the committee was of the opinion that investigation is to be completed on a case-to-case basis, and as no single rule applies to all cases, and accordingly, the FIC was
Commissioner এখন affidavit দিছে। Inquiry commissioner এখন affidavit দিছে। Copy to us, মানে timeless copy. Commissioner. Right.
The investigation completed that. Step.
Yes, Mr. They have completed and taken action against the.
No, my lord, it is not like that, my lord. What they are doing, if my lord, maybe I am troubling my lordships with an affidavit, my lord, filed by the commission itself before my lordships, my lord. If my lord may be pleased to take up paragraph 8, my lord. A small paragraph, my lord.
Page.
Page, my lord, it is, earmark is not there, my lord. Paragraph 8 of the affidavit filed by the commission, my lord.
The paper book page number.
Is, but, and it was filed earlier, that page numbers, process was there, my lord.
Who is the deponent?
Deponent is the secretary of the commission, my lord, Bhaskar Jyoti Sharma, filed on 19th day of October 2023, my lord.
19th October.
My lord. And filed on behalf of the respondent number 5, my lord. My lord.
No affidavit of 19th of October.
Lord, is
Sir, what is the order you are seeking in this PIL?
Lord, the order we are seeking in the PIL basically is twofold, my lord. Firstly, my lord, that the department should take action basing on the, my lord, commission's inquiry report, my lord.
Action means how? What
Action means, my lord, removal of these persons from the service, my lord, because they are
Without following the due procedure of law.
No, my lord, they are not required to follow the due process of law because they are very entry into the service, my lord. My lord, on that point, my lord, I can satisfy my lordships with the various judgments.
Say that
My lord.
since their entry in the service as per the SIT report
My lord.
is illegal without even providing any opportunity of hearing or without following the due procedure of law, they can be removed.
Yes, my lord. Yes, my lord. And secondly, my lord, this inquiry commission's report should be made public, my lord, because this includes the, my lord, the entire citizens of the state of Assam are being governed by these corrupt people, my lord. So therefore, my lord, no, my lord, the inquiry commission's report, if my lord may be pleased to, my lord can call for the inquiry commission's report and peruse the same also, my lord, how far illegalities and what type of, my lord, malpractices they have done while they, my lord, make themselves entry into the service, my lord. If my lordship may be pleased to give me some time, my lord, there are catena of judgments of the Honorable Apex Court, my lord, in such type of corruptions, my lord, these persons are not entitled even to, my lord, principle of natural justice, my lord.
These selections took place in which year?
2013 and 14, my lord.
2013
And 14, my lord.
And in the very same year, those persons were appointed.
Yes, yes, my lord. Subsequently, they were appointed in the year 2015, my lord.
Yeah.
And my lord, thereafter, these all allegations are came up. The PIL has been, my lord, the honorable, this matter also traveled to the Honorable Apex Court also, my lord. The government and the Honorable Apex Court has also upheld that the one-man inquiry commission should be there and it should conducted the inquiry.
Now the one-man inquiry,
My lord.
commission inquiry report is there.
My
On
lord.
the basis of that, the
My
state
lord.
government has already constituted a
No, no, my lord,
SIT.
not. Basing on that inquiry report, that SIT has not been constituted, my lord. SIT is for a different purpose. They have constituted, my lord.
Considering that only.
No, no, my lord, that is,
51.
my lord, the SIT issue is in a different pleadings, in a different writ petition. Writ appeal is also pending before this honorable court, my lord.
These candidate.
My lord.
These is my DP already. Special judge report me report the prosecution. PIL में क्या
Mission So, my lord, may I pray, my lord, that these persons, my lord, this 37 person whose name has been included in the, my lord, that one-man inquiry commission's report, my lord, in every person's, my lord, in what manner they have committed the, my lord, forgery, my lord, tempering of marks, how they have, my lord, even changed the answer scripts, that reports are available in that in one-man inquiry commission's report.
Mr. Bhuya,
My lord,
the SIT report submitted in seal cover shows
my lord,
that departmental proceeding has been initiated against 30 of these candidates. One did not join.
my lord,
So that will take its own process.
my lord.
And as regards others, they are waiting for prosecution sanction. Otherwise, the report will be presented before the special judges
My
court
lord,
very soon.
my lord.
There is nothing else that can be done at this stage in this case. You may make your arguments, we'll pass the final order here. Your purpose of the PIL has been served. SIT has been conducted. They have
My lord.
found people guilty, but action has to be taken in accordance with law, not by a mandate or a mandamus in the PIL. That's the law. We'll follow that.
Then, my lord, my lord, I have to, my lord, oblige with the observation of my
You
lordship.
cannot have a look at this today. That's not possible.
No, my lord, I
This is
cannot.
a confidential document.
No, my lord, I am not also, my lord, praying or, my lord, submitting before my lordship that copy should be furnished to us, my lord. But only one thing, my lord, may I pray, my lord, that the one-man inquiry commission's report, if lordship may be pleased to peruse, my lord, the intensity and the magnitude of the, my lord, corruptions which they have done. If my lordship may be pleased to peruse the report, my lordship will also be pleased.
What? We are
My
not
lord.
going to go and inquire.
Then, my lord,
They have already conducted inquiry and found people guilty.
But my
Why
lord,
aren't you
the
understanding this?
mandate of law is that, my lord, the Honorable Apex Court has settled that such type of entry of the service, my lord, otherwise they are protecting these people, my lord. They are not coming, my lord, even they are not entitled to, my lord, they are not entitled to even the procedure of the Assam Service Discipline and Appeal Rules as well as the any inquiry, my lord. They should be straight away, my lord, should be removed from the service, my lord. So, my lord, may I pray, my lord, on that line, my lord, I will try to satisfy my lordships. A short date may be given, my lord.
Seal cover में इसको retain. Registered keeper. Okay. We will give liberty to the state.
Because this is a very
We'll also give liberty to the state to proceed in the matter.
Mr. Dinath Ranit, senior advocate, the senior government advocate, Assam, has produced the report of the SIT in the sealed cover, has produced the status report in respect of the criminal case number 936/2016, registered under the provisions of Prevention of Corruption Act as well as IPC. Full stop. We peruse the report. They submitted the report in sealed envelope. They peruse the report. Then counsel appearing for the petitioner has submitted that in view of the observations made by this court in its decision dated 15/10/2015
My lord.
and in PIL number 48/2015 and other connected PILs, and in view of the one-man commission report, the state government is required to take action against the guilty persons without adhering to the procedure as prescribed in the departmental proceedings.
My lord, Assam Service Discipline and Appeal Rules, the other rules, my lord. My lord.
Disciplinary so and so rules. and it, once an appearing for the petitioner seek some time to address the court on this issue.
My lord.
Admit no need to issue notices as parties are already represented. The status report produced by Mr. Dinath be placed on record in sealed envelope. List in due courts.
My lord.
This
Obliged.
dependency will not be a part of this statement. Dependency of this writ petition will not operate as a bar against the state to proceed against the guilty persons, against the guilty person in accordance with the law.
My lord. Obliged, my lord.
Item 32.
In this case, we have filed our reply today, Your Lord. Today we will file, Your Lordship. It is in the process of filing, Your Lordship.
You are filing counter to the reply.
To the affidavit in opposition filed by them.
Ethical and a concept of the petitioner has submitted that counter to the reply of the state government is filed today. It takes some time. Less than 4 weeks.
Lords, obliged.
Item 33.
Item number 33, I'm issuing for respond number 4 minor. Lordship, we have prepared an interlocutory application.
For what?
Striking our name minor.
For striking your name.
Yes, your lordship.
You are respondent number.
Respond number 4 minor.
For your paid for striking your name.
Lordship, because I am not the owner of the brick lane.
Who is the owner? Who is the owner there?
Lordship, I am not minor.
You are not, but who is the owner there?
They have not made them as a party responsible.
But you inform us who is the owner. It's a public interest petition.
Lordship.
Who is the owner there?
I am not bad, Lordship, from the instruction received from my client. That the license is not in his name, your Lordship.
The license is his son's name or wife's name or who, in whose name the license?
Son.
Son's name. You are equally responsible.
He may be made the party respond. I'm not the owner of the land, not the license holder of the brick lane industry. I've to the effect, I've filed IA as well as the affidavit in opposition.
But that IA is not here.
It is.
It is not listed today.
It's there. Doesn't file. Doesn't. And your Lordship.
What do you want to say, Mr.?
Lordship, that grievance I have highlighted in this petition, already highlighting those grievances, I have filed on representation before the circle officer, and circle officer is the authorized person to issue certificate regarding distance. And my main contention is distance. It is the guideline says where population is more than 1,000, a specific distance has to be maintained to avoid the pollution. But here in my case, they have set up the brick industry within the village. It's surrounded by the population. So it is pollution, it is creating pollution and which is affecting the vegetation and agriculture as well as the population.
But now their application is there, you prayed for closing of this brick lane. This is what your prayer is.
My prayer is that the notice.
Stop illegal brick lane, especially village.
Stop.
Construction of illegal brick lane.
So now you are praying for that the brick lane operated by the respondent number 5 be stopped. This is what your prayer is.
I have a 1, 2, 3, 4 prayer, and one of the prayer is that to issue notice under section 31A of the
Why
ARA.
this nature of so and so direction shall not be issued, directing the respondents to stop illegal brick lane at village so and so. This is what the main prayer is.
Lordship, I have
You
also another.
made that brick lane also a party, but here now the application is that the person who is named in the writ petition is not the owner of the.
Absolutely true. His son is the owner.
So madam party,
Lordship, at this stage, I am not, the dependency of the litigation may not serve any purpose because Lordship direct the circle officer to dispose the representation.
that we can do. IA comes upon for consideration. The IA preferred on behalf of the one Biren Dika,
Number 4.
who is included as respondent number 4 in the PIL number 77/2023 with the prayer for striking his name from the array of the respondents on the ground that he is not the owner of DBI brick industry. Full stop. Learned counsel appearing for the petitioner is not in position to dispute the fact that the respondent, that the person who is included as respondent number 4 in PIL number 77/2023 is not the owner of the DI Bricklin. What is the name of that? DGI or DI?
DBI.
DGI Bricklin. DBI brick industry. Full stop. In view of the above, the IA is allowed. The name of the respondent number 4 is deleted from the array of the respondents in PIL number 77/2023. Now,
IA stands disposed of.
IA stands. In this PIL petition, then it concept for the petitioners have prayed as alleged that the one brick industry is established in village Barakhat, PO Sonapur, completely in violation of the law. Full stop. Learned concept for the plan, the petitioner has submitted that the petitioners have already filed a representation before whom?
Circle officer.
Before the circle officer,
Sonapur Revenue.
Sonapur Revenue Circle,
That's the respondent number 3.
included as respondent number 3 with the prayer for closing the brick lane set up in the village Barakhat, PO Sonapur, as the same is established in violation of the established rules. Stop. Then it consent for the petitioner submitted that the petitioner would be satisfied if the circle officer is directed to consider and decide the representation filed on behalf of the petitioner on 29/8/2023 within stipulated time. Stop. Having considered the request made by the learned counsel for the petitioner, we deem it appropriate to dispose of this PIL petition with a direction to the circle officer, Sonapur Revenue Circle, to consider and decide the representation filed on behalf of the petitioner dated 29/8/2023, if the same has not been decided till date, expeditiously, preferably within a period of 2 months after providing reasonable opportunity to the petitioners as well as the owner of the DBI brick industry in accordance with law.
Obliged.
Item 34.
Blacklisting.
Otherwise, the matter of blacklisting, the blacklisting is otherwise has spent its course. 2019 blacklisting for 2 years.
No,
Now
your
we are
lordship,
waiting
there are, your lordship, so far as this, along with the blacklisting, your lordship, there are some penalty imposed, your
But
lordship.
that are not under challenge here. Those are separate orders of penalty, which however not been challenged in the petition. I do not know how it can be brought up. now.
Lordship will kindly see, your lordship, what has happened, that order imposing penalty has never been served on me, your lordship. During the pendency of the,
And this,
Not a,
whether you challenge these penalty.
no, your
orders,
lordship, during the pendency of the writ petition, when we came to know about this, your lordship, and then your lordship, we immediately filed an IA, your lordship, in the writ petition, your lordship, and that, by that, your lordship, we have brought into that into the notice.
That IA for amending the petition,
Yes, your lordship, in the interlocutory application, your lordship.
interlocutory application
Not for
for amending the petition.
Not amending, your lordship.
Then
That your
again,
lordship,
detail
now
that
your,
IA
if your
So
lordship,
without there being any relief prayed for in the writ petition, how can we file?
your lordship will kindly see what has happened, your lordship, in this case. In fact, your lordship, even when we have your lordship, we came to know by a communication issued by the your lordship Guwahati refinery when we went there to demand certain amount of money, your lordship, pending.
Page 64 is the prayer.
Yes, your lordship, that's the prayer, your lordship. Page 64 is the prayer. It is there, your lordship.
64.
64 is the prayer, your lordship.
After the appeal.
Until then, your lordship, we did not know.
Contain the
your
writ
lordship.
petition. So
I will place the facts, your lordship.
and in fact that IA is also not a part of this writ appeal memo.
Yes, yes, it is. I will show.
Just
This is page 82.
okay, just hold.
Page 92 is the prayer. If your lordship comes to page
Just a
100,
minute.
Lord.
before the learned single judge, you have not challenged the order of that penalty or whatever it may be.
Lordship, that in the main writ petition, it was not there, Your Lordship.
Not there.
Because, Your Lordship, at the relevant point of time, Your Lordship, when we filed it in the month of July, Your Lordship, this order, only one order was communicated to us, Your Lordship, that is the order dated 3/7/2019, whereby, Your Lordship, we are blacklisted. Now, if Your Lordship comes to page 100 of my writ appeal, Your Lordship, now, even on that day, Your Lordship, no formal order has been, Your Lordship, served on us, Your Lordship. There is a communication, Your Lordship will get it at page 100.
Okay, yes, no formal your penalized, his order was passed there.
Lord.
Then
In page 100, Your Lordship, when we demanded certain amount from the Guwahati refinery, Your Lordship, this letter was, Your Lordship, issued. It says, Your Lordship, Digboi refinery has advised to impose the following penal action on a transporter so-and-so, which was found to be involved in malpractice so-and-so carried on from Digboi refinery so-and-so, Your Lordship. Now, in view of this, Your Lordship, what we did, Your Lordship, we filed an interlocutory application, Your Lordship,
before
the honorable single judge, Your Lordship.
then
And then, Your Lordship, in that interlocutory application, there is an order, Your Lordship, of Your Lordship, interim order, Your Lordship, directing them to not to take any coercive action, Your Lordship. And finally, when the matter was heard, Your Lordship, that aspect has, Your Lordship, not gone into by the honorable single judge, Your Lordship. And only on that point.
that fair opportunity was granted to you. That's all.
No, Your Lordship will kindly see that the basis of this imposition of penalty and the blacklisting was a particular report, Your Lordship. That report has never been furnished to me, Your Lordship. Only that because, Your Lordship, that report, Your Lordship, has been on the basis of that report, Your Lordship, they have, Your Lordship, imposed this penalty, Your Lordship. But that particular report, Your Lordship will get it,
Where is that report?
Your Lordship, I would say. That report, Your Lordship, will get it at page, Your Lordship, 188, Your Lordship.
Yes.
Page 190, Your Lordship.
Yes.
There are 3-member committee, Your Lordship. Committee report on anomaly with so-and-so, submitted on 35/2019. Members, 1 K.K. Pandey, P.K. Roy, and Borman, Your Lordship.
But the inspection report, it was done in presence of your person and.
No, not the initial inspection, Your Lordship. If Your Lordship comes to that report, Your Lordship will find
Page 188.
page 188, Your Lordship.
Serial number 5 is
189, Your Lordship, may kindly come. Your Lordship will find it can be clearly seen that the test results of Guwahati refinery and Digboi are not matching. Detailed analysis and report will be submitted by the committee shortly. Your Lordship, till then, Your Lordship, there was no finding, Your Lordship, that what contaminated that particular, Your Lordship, Your Lordship, two of the boxes, Your Lordship. Now, if Your Lordship comes to page 188, tentative view, Your Lordship will get that the tanker chambers were found to be covered with a box type arrangement.
Yeah, first listing. First listing. First listing. I made it.
We'll hear it in due course. That's the norm. Admit.
Lord.
No need to show that these parties are already represented. You are taking a risk. In fact,
Lordship, in this
you
case,
can very well challenge that penalty order separately, but you are taking a risk here. Okay.
Lordship.
So you're there.
Item 46.
The government of Assam here has filed the visible matter, they have received the copy matter, we will file a reply within 10 days.
As per the this government of Assam reply, some matter before the Supreme Court is also
No, that is
pending
different.
or disposed of.
That is on the performance of the board, trust board, the management.
regarding the same project, we informed the Honorable Supreme Court, and Honorable Supreme Court was pleased to pass a specific direction that we follow whatever assurance we give before the Honorable Supreme Court and implement this scheme of PM Divine scheme regarding the Kamakhya corridor in true letter and spirit.
But here, they are challenging that, you have filed your detailed reply that there is
Yes,
no.
we have detailed reply, and the NIT, which is annexed in the reply itself clearly says there is no scope of any disturbance of the existing shrine. It is the corridor for betterment of the facilities to the pilgrim, nothing to do with the main shrine or any of the temples. He has totally misconceived petition, Lord.
Let them file it.
Reply, the counter to the writ petition is filed on behalf of the respondent number 5, Government of Assam. The counsel appearing for the petitioner takes some time to file counter to the reply of the state of Assam.
10 days. 10 days time.
Take your own time. 10 days may you will not be able to file. 3 weeks.
Let me know 2 weeks, madam. 2 weeks.
But what is there in this, this
Now,
construction?
we'll reply. Whether they have got the authority at all, my lord, will reply thoroughly.
The state has clarified that they're not going to change the basic structure.
And totally misconceived, Lord. Totally on guesses and conjecture they have filed. Maybe with some ulterior motive.
There can be alternative, my lord, well, if persons living in Karnataka, Bengal and Delhi and other places. Can there be any alternative? Those who are the devotees
That my brother has already pointed out.
Yes.
That none of the person except one is
One is from Assam.
Guwahati.
All the people who will get affected because there are large scale commercial activities going on. We are going to remove everything. Nobody has come before this honorable court.
No, let them be evicted, they do commercial activity, we don't have. We have to only protect the shrine and the monuments. Oblige.
Pass over meters. Item 6.
If I have gotten instruction, the advocate representing the appellant, his mother is sick, so he's in hospital now.
This court on 21/2/2024 ordered for taking steps of service upon the respondent number 8 and 9.
7, 8 and 9.
7, 8 and 9. Stop, as per the office report, steps have not been taken. Mr. S.K. Goswami has informed that the mother of the concept of the petitioner is ill and therefore he is not attending court today. Be that as it may, list after 2 weeks. In the meantime, counsel for the appellant may take steps for service of notice upon the respondent number 7, 8 and 9. You inform them.
Okay.
Pass over meter 12.
My lord, I tried to contact, my lord, I'm unable to contact, my lord. But at page 365, my lord, the affidavit which I have filed, there I have given the details of the service of notice. The few respondents are from outside the state of.
What happened to the advocate? What they've said?
My lord, he's now saying that he's not appearing, my lord, he's refused. My lord. My lord, most of the respondents are from state of Mizoram.
As per the office report,
They are served, my lord.
the notices upon the respondent number 1 to 145 have been served through paper publication.
No, my lord, I will correct it, my lord. My lord, you take page 365, my lord, for a moment, of the affidavit which I have filed.
Yes. 365.
365, my lord, paragraph 3.
When you have filed this affidavit?
My lord,
Affidavit is not on record.
it is filed, my lord. 9/4.
So what do you have mentioned in the affidavit? What do you have mentioned?
My
in
lord,
the-
they have mentioned that, my lord, the respondent numbers, my lord, they are different respondents, my lord. And 129 number of respondents are from state of Mizoram. Serial numbers are different, my lord.
Then the concept of the petitioner has submitted that he has submitted an affidavit regarding the service of notice upon the respondents through by substituting paper publication. Office is directed to place on record the said affidavit. It's after 2 weeks.
My lord, can it be before that, my lord? There is some urgency, my lord. The contempt has been filed.
10 days.
My lord. Obliged.
Yes.
Pass-over-meter 20.
In this case, Mala, Assam University is supposed to file the affidavit, Mala, because their affidavit is essential. Therefore,
Some university, what do you do? Some university equivalence report is already there.
no, my lord, the equivalence report now after the UGC regulation 2018, and there is a distinction between the 2010 regulation and 2018 regulation. Earlier, it was equivalent. Now it is not equivalent. It is allied, concerned,
Secondary
and the
Education Department appearing for the submitted an expert committee has
This is
considered
not-
the matter regarding equivalence of the degree possessed by the petitioner, degree MSc July, and found that the degree MSc in microbiology is not equivalent to degree in the MSc in geology.
that is the modern manner they have adopted, my lord, is not correct. That is not, my lord, that is because those are not experts. They are the college teachers. Expert has to be from the university level, my lord. And
But sir, we are also not experts. How can we assess that that expert committee is?
and the concept of, my lord, and the concept of life science has changed now. Now, earlier it was zoology, botany. Biology was the main subject, and two streams were there, zoology and botany. Now it has more than 16 subjects are there in the life science department, my lord. And UGC has therefore, my lord, in the 2018 regulation, it is changed now. It is allied. It is a combination of allied subjects.
Mr. Contrail.
Therefore, my lord, university has constituted.
Can we sit over the recommendations of the committee?
Yes, my lord, it will be placed before the high-level committee on the basis of the report of the university, my lord. So, university, they are the party, my lord. It is the only university in the Assam University having this subject.
If the Assam University is not willing to file any reply, then
They have constituted a committee, my lord. I have heard. They have constituted
that constituted committee has already submitted its report.
university level professors. University level professors have constituted a committee, my lord, to examine this aspect, and they'll file it.
For the Assam University.
But we have constituted a committee given
For what?
for assessing the issue involving the petition. But if
Then the earlier committee, who formed that earlier committee?
the state of Assam.
State of Assam without, my lord, having the.
All the committee members, they've been given responsibility in the election, so they cannot submit a report.
Okay, Mr. Hale, appearing on behalf of the Assam University. Takes some time to complete his instructions. Let's start with this.
Obliged.
For hearing, item 37.
Lordship, my senior is busy on another court. Kindly pass over the matter for a time being.
But after this matter, we have no other matter.
Lordship, kindly adjourn the matter for the day.
Is not available, then what to do? 2 weeks.
No, when the court that may be given, otherwise,
Yes, my
it's a
lord.
matter of 2019 law banning, my lord.
Okay, 2nd of May. We have the above discussion, we have no hesitation in holding that the learned single judge has not committed any illegality in setting aside the termination order dated 19/4/2023 issued by the registrar KKHSCU terminating the services of the respondent as professor in Bhupera Hazarika School of Mass Communication and as rightly ordered for reinstating the respondent number 1 writ petitioner in service forthwith on the said post with all consequential benefits. However, the appellant university can very well proceed against the respondent number 1 writ petitioner by providing him sufficient opportunity of hearing without adhering to the procedure laid down under the service rules 2019. The appellant university is free to proceed against the respondent number 1 writ petitioner, but after providing sufficient opportunity of hearing to him, the appellant university is directed to provide sufficient time to the respondent number 1 writ petitioner to furnish his explanation reply, and after receiving the same, the proceedings initiated against the respondent number 1 writ petitioner can be dropped if the appellant university finds explanation reply filed by the respondent number 1 writ petitioner satisfactory. However, in case the university decides otherwise, it shall pass a speaking and reasoned order in that. With these observations, these writ appeals stand disposed of, no costs.